probate. And so I want you to tell us what exactly is a probate and what purpose does it serve for the ordinary person.
Probate in its simplest terms is attending, in its simplest terms. Probate is a process by which a will is authenticated, authorized, or just tested to see if it can stand up to scrutiny by a court. That really is the purpose of a probate. It tests the validity of a will to ensure that the beneficiaries are persons who are named in the will to get usually a piece of property, is worthy of getting that, and to test if the will itself is valid. Oftentimes there are fraudulent activities surrounding a will, so that is the purpose of probate, to ensure that the will is valid.
Excellent. So the probate is something that is tied to the will. So
yes,
talking about the will, is it always necessary for someone to create a will? If you know, you already tell your loved ones what is left for them, what is then the necessity of creating a will, particularly, let's say in the world, but particularly in the Caribbean? What's the necessity of creating that will?
A human being ceases to talk after he or she passes. The will is what will talk for you after you pass. Even though you have the best of intentions and you may tell your loved ones that A will get the big house, B will get the greenhouse, and C will get the farm, you have no control over who gets what after you have passed if you do not put in writing. One of the most troublesome areas of law appears now to me to be probate, and we not planning for afterlife. There's a very sad notion that if you make a will, you're preparing to die, but that is not the case. The will ensures that all your loved ones or all your beneficiaries are given the properties, the assets, or your wishes are expressed after you have gone. And it eliminates a myriad of problems. Oftentimes, we'll hear of a person dying without a will, and the cousin who left Jamaica 30 years ago, you may not have met him or her, that person fly down and wants to take over the family house, and that person might not have been the best person in law who would be able to benefit from the house. So when you put your affairs in order, nicely written by an attorney in a will, it will take away the pain of your loved ones having to go through the hassle of court battles sometimes, and just the hassle of harassment from persons who are not beneficiaries. So it is essential that as soon as we start acquiring assets, just pen a will. Just pen something and ensure that your loved ones, especially if we have children, they are taken care of.
That is such a great point, Ms. Duane, because this one is near and dear to me. And so I'm going to dig a little deeper into this one, because I know the older persons, particularly our older parents, they shied away from writing wills, because as you said before, some of them believe that when you write a will, you're planning to die. So this one is near and dear to me. My own father died in 2020 at the age of 90. And he did not leave a will, but he left some property. So my next question is, when a parent dies and leaves some property without a will, how do the family member take possession of that property? Because this is also a question I want answered.
Yes. As I mentioned earlier, Jamaicans, we are cowards. As bad as you see we are cowards. We don't like to plan for afterlife. In your particular case, the fact that your father died without a will, we'll have to apply for a process called letters of administration. That's the flip side of probate. Probate, you check to see the validity of the will to ensure that the beneficiaries receive what is left for them in writing. The flip side is, so when somebody dies intestate without a will, we apply for letters of administration. These are covered by the laws of intestacy. So the court looks to see how many beneficiaries or how many relatives, using a scale, how many relatives are left behind. Did your father die leaving your mother? That's a question, Dr. Brooks. Did your father die leaving your mother?
I'm listening to you, and the good thing is that it's just myself and my sister, so we don't have a lot to deal with.
Okay, so the fact that it is just two beneficiaries, two persons who are left, what happens is that an attorney at law can apply to the court to say to the state that there are two beneficiaries who are left, yourself and your sister. Kindly afford them the courtesies of having the properties left behind by the deceased, that they be named as the beneficiaries. So that's the flip side of probate. So not because somebody doesn't die with a will, it doesn't mean that what is left behind cannot be passed on to the relatives. It can be done without a will.
Thank you so much for that information again. And let me just pause to say, if you are just joining the room, you are in the fireside chat with Dr. Janice. This is where we meet each Tuesday at this time, 8 p.m. Eastern. It's where we have those conversations. It's where we learn, and it's where we grow. The fireside is all about building people and changing lives. We have been going for almost 2 years now, have brought in over 70 guests in here, and have had many conversations that have helped people to change their lives. Tonight is one of those nights. And here with us is attorney at law, Carrie-Ann Duaney. She joins us to share with us her field of expertise as we go through this month, highlighting influential women who are making an impact in their field. And so my next question, Ms. Duaney, to you is, oftentimes, and I'm